Good day everyone, I am Michael, the moderator for this webinar. I welcome everyone for today's webinar, which is HIPAA changes for 2024 and beyond. I would now like to introduce our presenter for today, Mark R. Prengelman. Mark holds bachelor and master degrees in philosophy from Emory University and a Juris Doctorate from University of Kentucky. I would now like to hand over the floor to the speaker. Over to you, Mark.
Thank you, Michael, for that excellent introduction, just as I wrote it. It's a pleasure to be here. So good afternoon to everyone. So we have a 60-minute webinar that I think you'll find interesting and informative, and it'll be a good worthwhile use of our time today. Today's topic is HIPAA changes for 2024 and beyond. An introduction to federal regulatory process notice and comment rulemaking, an overview of the privacy rule changes for 2023. You will see that that has been the subject of its own prior standalone webinar, so I just want to hit the highlights for that. Why these changes are extended into 2024, the HIPAA security and privacy rule to explain what's the difference, if there is a difference anymore, training your employees, what's really required. We will also cover cybersecurity, why it's more important now, self-audits, remediation and implementation of improvements, best practices for responding to a security incident, and lessons learned from the most recent cyberattack investigation. Cybersecurity sanctions policies will be reviewed to support HIPAA compliance, and a conclusion with avoiding risk and liability with best practices to anticipate HIPAA changes for 2024, but not yet in effect. These are coming. I do think it's important to give the disclaimers for the content of this program so that we know we're all on the same page together about what this does and does not cover. This does provide a broad overview of anticipated proposed HIPAA changes for 2024 in the federal notice and comment rulemaking system, but it doesn't cover everything about anticipated proposed HIPAA changes. The current proposed rule changes were filed in 2023, and they consisted of 48 pages in the Federal Register. It does educate each and every one of you, all of you out there across all 4 time zones attending, to ask the right questions in your own profession, your own healthcare entity and facility about changes in compliance with federal law to look for in 2024. Introduction to HIPAA changes for 2024. We start with this year's 2023 rule changes. Why? Because the Federal Department of Health and Human Services published proposed amendments to HIPAA to further safeguard the privacy of reproductive health care in 2023, specifically April 17th, 2023. Now here it is, December. This was the biggest change in the proposed rules in I don't even know how long. This had to be a once in a 10-year type event, and it's still unfolding. Under the federal system, comments were due by the public or any interested party due 60 days later by June 16th of this summer. At the time, so why 2023 to start with, focusing on 2024? These were proposed significant rule changes that incorporated existing federal guidance documents into the black and white letter of the law. This was in response to the 18-month-old now U.S. Supreme Court decision in Dobbs versus Jackson Women's Health Organization, the decision on abortion recognizing state-by-state differences, even more so now in 2023 and 2024. The proposed amended HIPAA rule prohibits the use and disclosure of this information for certain criminal, civil, and administrative investigations and proceedings where reproductive health care is legal and lawful in the state that it was provided or under federal law. The HIPAA update would preempt contrary state law in those very narrow situations. For 2023, there are also proposed corresponding changes, such as to the requirements for notices of privacy practices and requiring attestations for certain requests for information potentially related to reproductive health care. So after the Supreme Court officially published the Dobbs case, they issued existing guidance. The feds, through the Health and Human Services Department, issued an existing guidance. What is a guidance document? Does it have the force of law? Well, yes and no. Guidance documents are suggestions to individuals regarding how to comply with the law. It's kind of commentary. It's kind of I mean, so just as an example of a guidance would be if the law said you shall use a secure digital platform, quote unquote, use a secure digital platform. And the guidance document says, well, we kind of need to go beyond that, and we're going to say that 16-bit double-ended encryption is secure. But only the law can mandate the use of 16-bit double-ended encryption as being required under the law. Why guidance is not enough? The second guidance document clarified that HIPAA does not apply to health information on consumer devices or stored with most consumer apps or applications, which is otherwise the existing HIPAA laws as we know. So in conclusion for this introduction to HIPAA changes for 2024 and beyond, these proposed changes for 2023 and extending into 2024 will involve next steps for covered entities and business associates alike. This is still ongoing. Introduction to federal regulatory process, notice and comment rulemaking. So the emphasis is on state rulemaking and similarities to federal government. The proposed rule is filed as it does for HIPAA. There is written notice to the public. Rulemaking is the policy-making process for executive and independent agencies of the federal government, analogous to state government, using the process to develop and issue rules, often referred to as regulations. In my state, they're called administrative regulations. At the state level, some states refer to them as rules, but the process is governed by laws, including but not limited to this Federal Administrative Procedures Act. So let's get into the meat of HIPAA privacy and security, the changes for 2024 and beyond. What's the difference now between security and privacy? These concepts are merging as a result of the evolution of electronic health records and direct patient access on secured health applications, apps on your smartphone. It used to be the case that privacy and security were two distinct concepts. Now the two rules seem to be alike in many ways. Patients more clearly have a right in 2024 to have direct access to their own medical records. In the absence of that kind of direct access, covered entities in turn have to respond to individual and specific requests to verify the identity of the person requesting the medical record and to handle correctly medical records, data, and protected health information with third parties. Note that has always been true with business associates who stand in the shoes of covered entities, and smartphone apps raise this liability if you can access your protected health information through the miracle of your smartphone. Training your employees, what is really required coming for 2024? The initial training versus training and needing. All new employees and persons have to have initial training on HIPAA, and you give training, regular training as needed. So you do initial training, you probably should do annual training, and anytime there's a big change, you might need to organize something for your people. It needs to address cyber awareness and especially phishing. Focus on phishing. Healthcare is the most vulnerable to cyber hackers. Two-factor identification is the easiest, most efficient way to protect sensitive information. Training your employees, what's really required for 2024 and beyond? Employee and worker education are critical. This must include all employees and volunteers at every level. So differentiate between workers who have direct access to medical records and protected health information versus others.